Before the police arrived, someone made sure they would not find everything. On October 7, 2005, the Palm Beach Police Department executed a search warrant on Jeffrey Epstein's Florida mansion. They were investigating allegations that a 14-year-old girl had been molested inside that home. They arrived expecting to find computers, records, evidence. What they found instead was a property that had already been cleaned out. The police chief who led that raid would later say plainly, the place had been cleaned up. Certain computer material appeared to be gone. Someone had been in that house before law enforcement and removed the things that mattered most. What we now know, through documents released in the Epstein files and confirmed through court records and investigative reporting, is that Epstein had hired a private investigation firm to physically remove items from his Palm Beach property in the days before that search warrant was executed. Those items were placed into a storage facility nearby. And according to reporting from the Telegraph, confirmed against documents now in the public record, that storage unit was never searched by the FBI. The evidence that could have changed the course of this entire investigation sat in a storage facility for years. Untouched. Unsearched. Unaccounted for. This is Case Analysis Bureau. And what I am about to take you through is not a list of items for shock value. It is a careful examination of what those documents reveal about a deliberate, premeditated effort to obstruct a criminal investigation into the sexual abuse of children, and what it means for the survivors who have spent 2 decades waiting for full accountability. Subscribe to Case Analysis Bureau and turn on notifications. The Epstein files continue to be released and we analyze every significant document the moment it becomes public. Before we go further, drop a comment right now and answer this. Do you believe the full truth about this investigation has ever been told? Yes or no, tell us below. We read every comment. Now let's go through what these documents actually reveal. Before we examine a single document from that storage inventory, I want to take a moment to establish something that every piece of analysis in this video needs to be understood through. This case is not about Jeffrey Epstein. He died in a federal detention facility in August of 2019 while awaiting trial on federal charges of sex trafficking of minors. Whatever accountability he avoided in life, he will not face a jury. That chapter is closed. This case is about the survivors. The women, many of them girls when the abuse occurred, who came forward, who gave testimony, who filed civil suits, who spent years being dismissed, disbelieved, and in some cases actively targeted by Epstein's legal and investigative apparatus. Virginia Giuffre. The Jane Does whose names were redacted in court filings to protect their identities. The 14-year-old girl whose family's report to police in 2004 set this entire chain of events in motion. Every item that was removed from that Palm Beach mansion before the 2005 raid was potential evidence in a case that those survivors needed to be taken seriously. Every document that was locked in a storage unit was a piece of a prosecution that never happened the way it should have. The cover-up described in these documents is not an abstraction. It is the reason so many of these women waited so long for justice that never fully came. That is the lens through which every document in this analysis needs to be understood. Let me take you back to 2004 and 2005, because understanding the timeline of this investigation is essential to understanding why what happened with that storage unit matters as much as it does. In 2004, the family of a 14-year-old girl reported to Palm Beach police that she had been sexually abused at Jeffrey Epstein's mansion. Detectives began investigating. They identified additional victims. They built a case. And in October of 2005, they executed a search warrant on Epstein's Palm Beach property. What investigators found during that raid included receipts, physical records indicating that certain items had existed in that home. But the items themselves were not there. Computers. Files. Materials of potential evidentiary value. The receipts showed they had been present. The house showed they had been removed. We now know from court documents and investigative reporting exactly how that removal happened. Epstein had retained a private investigation firm. On October 7, 2005, in anticipation of the search warrant, an investigator named Paul Lavieri visited the Palm Beach residence and, pursuant to instructions from Epstein's attorney Roy Black, removed items of potential evidentiary value from the home. Those items were transferred to another investigator, William Riley, and placed into secure storage. An email from August of 2009, roughly 1 month after Epstein was released from his 13-month prison sentence, makes the situation even clearer. Riley wrote to Epstein's legal team, "Over the weekend I learned that the plaintiff's counsel are looking to obtain from me the computers and paperwork I took from Jeff's house prior to the search warrant. I have them locked in storage and would like to know what to do with them." Prior to the search warrant. That phrase is the center of this entire story. Items were removed from a property under active criminal investigation, before law enforcement could recover them, and placed into storage where they remained, according to reporting from the Telegraph, without ever being searched by the FBI. In a 2010 deposition from a civil case filed against Epstein, he was asked directly whether he had directed someone to remove at least 3 computers from his home prior to the search warrant execution. He invoked his Fifth Amendment right against self-incrimination. He was asked where those computers were. Fifth Amendment. He was asked whether those computers contained the names and contact details of underage girls he had sexually abused. Fifth Amendment. He answered nothing. And for years, neither did the storage unit. An October 2009 email, sent from William Riley to Epstein's attorney Roy Black, approximately 3 months after Epstein's release from jail, contained an attached inventory of everything that had been removed from the Palm Beach mansion and placed into that storage facility. That document is now part of the publicly released Epstein files. I am not going to go through this inventory item by item for shock value. What I am going to do is identify the categories of material that appear in that document and explain precisely why each category matters from an investigative and accountability standpoint. The computers. 3 computers were removed from the property before the search warrant was executed, 2 Dell machines and 1 HP Pavilion. These are not peripheral items. In a child sex crimes investigation, computers are among the most critical pieces of evidence investigators seek. They contain communications, files, contact records, and digital evidence that can establish patterns of behavior, identify additional victims, and connect suspects to specific crimes. The Palm Beach police had receipts showing computers had existed in that home. The computers themselves were gone. Hard drive copies were eventually recovered by the FBI years later, but the original machines, and whatever they contained beyond what was copied, had been removed. The telephone directories. More than 24 telephone directories were removed from the property. In the context of this investigation, in which Epstein's network of contacts, recruiters, and co-conspirators was central to understanding the full scope of the abuse, a collection of more than 20 directories containing names and numbers represents exactly the kind of evidence prosecutors would have sought. Virginia Giuffre and other survivors have consistently maintained that Epstein's operation involved a wide network of people who facilitated access to victims. Those directories may have contained names that were never fully investigated. The recordings. The inventory includes multiple recording devices, a metal tape with handwritten notations, VHS recordings, blank tapes, a tape recorder. What is significant here is not the existence of these items in isolation. It is the context in which they appear. Epstein's former pilot later confirmed in writing that he had purchased and installed motion sensor hidden cameras at Epstein's direction. Those cameras were described as being concealed inside ordinary household objects and capable of 64 hours of recording. The presence of recording equipment in the storage inventory, removed before law enforcement arrived, raises a direct question about whether footage of criminal activity existed and whether it was ever fully accounted for. The documents, the calendar, the personal correspondence, and the lab results. Among the items removed was a 2005 calendar. Given the timeline, this was the year of the search warrant, the year the investigation intensified. What Epstein had recorded in that calendar's appointments and entries could have been directly relevant to the criminal investigation. Also removed were personal letters, greeting cards, and, the detail that raises perhaps the most serious questions: medical lab results. What those results pertain to has never been publicly established. In the context of the allegations against Epstein, including claims involving multiple victims over many years, the significance of medical documentation removed before law enforcement arrived is self-evident. The identification documents. Among the removed items were several identification cards, including a Harvard University identification card and a Florida concealed weapons permit. Epstein had been designated a visiting fellow at Harvard's Department of Psychology in 2005, the same year of the raid. Despite his 2008 conviction on solicitation charges involving a minor, he continued to visit Harvard's campus more than 40 additional times and maintained an office there until 2018. Harvard did not publicly condemn its connection to Epstein until 2019, the year of his arrest and death. The question of why Epstein would have sought to remove his institutional identification documents before a search warrant was executed on child sex crime allegations remains unanswered. If you are still with me right now, drop a comment with "I'm still here." Let's see who is following every detail of this analysis. Hit that like button while you are there. It takes 1 second and it puts this investigation in front of people who deserve to know what these documents say. Now let's talk about what the failure to search that storage unit actually means for the survivors still seeking full accountability. Now let me bring you to the detail in this story that I believe matters more than anything else in the inventory. According to reporting from The Telegraph, cross-referenced against what is known from the publicly released Epstein files, the FBI never searched that storage unit. The FBI never searched the storage unit. Let that land for a moment. A private investigator removed materials of potential evidentiary value from the home of a man being investigated for child sex crimes. Those materials were placed into a storage facility. That investigator later sent an email to Epstein's legal team explicitly noting that he had the computers and paperwork taken from the house prior to the search warrant. The plaintiff's counsel in a civil case, survivors seeking accountability, were actively trying to access those materials. And the FBI, the federal law enforcement agency that eventually took over this investigation and built the 2019 case that led to Epstein's arrest, apparently never walked into that storage unit. Former Palm Beach Police Chief Michael Ryder, who led the original investigation, said clearly that when officers executed the search warrant on Epstein's property, the place had been cleaned up. His investigators found evidence that materials had existed and had been removed. They followed the trail as far as they could. But the storage unit, the destination for everything that had been cleared out, was apparently never reached. The implications of this for the survivors are significant and deserve to be stated plainly. The 2008 plea agreement that critics have called a sweetheart deal, in which Epstein pleaded guilty to state charges of soliciting prostitution and soliciting prostitution of a minor while avoiding federal charges, was negotiated in a context where potentially relevant evidence sat in an unsearched storage facility. The survivors who were excluded from that negotiation and who fought for years to have it overturned were fighting a system that may never have fully assembled the evidence that existed. Ghislaine Maxwell was convicted in 2021 on charges of sex trafficking of minors and related counts. She is serving a 20-year sentence. Her conviction represented a measure of accountability. But the question that the storage unit documents raise, how many people, how much evidence, how much of the full picture was never pursued, remains genuinely open. The survivors deserved a complete investigation. The documents suggest they may never have received one. There is one more piece of this story I want to bring to your attention before we close, because it speaks directly to the question of whether Epstein and those around him understood exactly what that storage unit contained and what it meant. In a 2010 civil deposition, Epstein was asked a series of direct questions about the removal of materials from his Palm Beach property. His responses were identical to each question. He invoked his rights under the 5th, 6th, and 14th Amendments. He declined to answer whether he had directed the removal of computers. He declined to answer where those computers were. He declined to answer whether those computers contained evidence of crimes against minors. A person who has nothing to hide does not invoke the Fifth Amendment in response to questions about where their computers are. The email trail tells the same story. William Riley's August 2009 message to Epstein's legal team was not the correspondence of someone who believed these items were irrelevant. He was asking what to do with materials he knew were being sought by survivors' legal counsel. He was asking whether to hand them to Epstein's personal lawyers. The response from the legal team, to clone the computer hard drives, handled by a forensic specialist, was not a casual administrative decision. It was a deliberate management of materials that everyone involved understood to be significant. The pattern here is consistent and clear. Items were removed before a search warrant. They were stored in a facility that was not searched. When asked about them under oath, Epstein refused to answer. When survivors' legal counsel sought access to them, the matter was managed through Epstein's legal apparatus. And now, years after his death, the full contents and fate of what was in that storage unit remain incompletely accounted for. I want to close this analysis where every Case Analysis Bureau video closes, with the people who matter most. The survivors of Jeffrey Epstein's abuse have spent decades navigating a system that repeatedly failed them. They were disbelieved. They were dismissed. In some cases they were actively targeted and intimidated by the people around Epstein. They fought for years to overturn the 2008 plea agreement that gave him what amounted to a minimal consequence for crimes that destroyed their childhoods and their sense of safety in the world. Some of them eventually received civil settlements. Ghislaine Maxwell's conviction brought a measure of justice. The 2019 federal case, had it proceeded to trial, might have brought more. But Epstein died in that detention cell, and the trial never happened, and the questions about co-conspirators who have never been charged remain as alive today as they were 20 years ago. What the storage unit documents tell us is that the investigation that could have answered those questions, the one that should have been conducted in 2005 with full access to everything that was in that Palm Beach mansion, was compromised before it began. The evidence was moved. The unit was not searched. The Fifth Amendment was invoked. And the survivors were left with a prosecution that never fully captured the scale of what had been done to them. The Epstein files continue to be released. New documents continue to surface. The full picture of what happened, who was involved, and what was known and when, that picture is still being assembled. And this channel will be here for every piece of it. The survivors waited long enough. The least the rest of us can do is keep asking the questions that still do not have answers. Before you go, leave your most important unanswered question about this case in the comments. What do you believe still needs to be investigated? Who do you believe still needs to be held accountable? This community does serious analysis together and we want to hear what you see. Subscribe to Case Analysis Bureau so you get every Epstein files update the moment new documents are released. This story is not over and we will be here for every development. If you know someone who follows this case closely, share this video with them right now. The survivors deserve for this story to stay in the public eye.